rise. We didn't particularly like it, but at least we felt like temp workers who have no guarantee of future employment every time they complete an assignment don't know when they're going to get additional hours or how much they're going to make that week. They deserve some level of certainty. And if we're going to essentially take away their rights by denying them immediate payment, we want to make sure that they're not having to wait the full 2 weeks. If they only work a few hours on a Monday, why should they have to wait a full 2 weeks to get those meager wages? We feel the same here. We don't feel that there is any special burden on this type of employer. In fact, when we met with them, they basically said, we're not temp employers and we're not paying weekly. We're paying every 2 weeks. Fine. If they're not temp employers and they're not complying with the law that only affects temporary employers, we didn't change the definition of temporary employers. We simply referenced the definition used in the UI code. So if they aren't temporary employers, we don't see how 940 impacted them, and we see no need to make any adjustments. We are very concerned that once we agree to exempt any one industry from the requirements of 940 and weekly pay, we are going to see 12 bills on this next year. Every other industry is going to say, well, here's why we should be able to do it differently. And I would just point out 940 specifically exempted nonprofits. So for the hospices and home care that are nonprofit, the weekly pay did not apply to them in the first place. Thanks very much. We are in strong opposition.
I'm Stephen Pingle, Mr. Chair and members from California Employment Lawyers Association. We're also in strong opposition to this for the same reasons Ms. Vega stated, but also because this really affects that low income level of employees who most need to have a regular pay, more regular than 2 weeks. 1 week was the compromise, and we urge you to keep that. Thank you.
Deanna Furman on behalf of the California Nurses Association. We too are also in opposition to this bill for all the reasons that Ms. Vega stated. Also, we believe that although home care and hospice RNs and other workers may find this to be a calling, and other nurses as well, we also believe that they deserve to be paid in a timely fashion.
Thank you. Any comments or questions? So Ms. Vega did not seem to believe that this classification of employees must comply with 940 because, as you've stated, they're not temporary workers. So where's where are we here on just the definition?
I don't do well then. My understanding is these are folks who work for the same organization but have different clients, which makes them temporary.
Yeah, our members don't think of ourselves as temp agencies. Unfortunately, just by the nature of the work, if Mrs. Smith passes away, then that work ends until there is another client, which almost always, because it's industry in demand, is maybe a day or two away. But we don't think of ourselves as a temp or as an independent contractor model or anything like that. But
I get that.
Under 940,
do you believe you need to comply with 940?
Yes, and we've gotten some opinions which make it that there's enough of a gray area. There is a liability, a huge liability, where if it went to litigation, that it's gray what the outcome would be, and that's why we say, well, there's this huge liability hanging out there. It would be easier if we just end the confusion now.
But doesn't that sort of answer the question before us that if it were to be litigated, some court would make the definitive statement, you must comply, and then that really does begin to dismantle what was a negotiation relative to part-time or temporary employees?
We've met with the Department of Industrial Relations. We asked them directly, are we interpreted as being a temporary services employer under the current law? And we were told directly, yes, because of the definition of discharge, other assignments of these workers. If there was a way out, we would take it, but there's no way out. So we have a choice of either complying with the law, paying weekly, or not complying with the law. They're choosing to comply with the law. That's why the legislation has not been sponsored on a lark. It's been sponsored for the purpose of trying to provide the clarity that we want, which is we do do not believe we should be included under the spirit of this. We understand that there is the slippery slope that this starts, but nonetheless, that's why we're here.
And it was not my intention to walk down a slippery slope, but looking at the gray area of the nature of the care, the nature of the client to organization relationship, it's not my intent to go into the part of the issue on how temporary employees are treated or not treated, or delve into those other, labor issues, which I strongly support and believe in. It was simply looking at the nature of the care, looking at the spirit of what these organizations do, to me, meant more towards permanent employment, and that's why I was willing to bring forth this bill to try to bring some clarity to the issue, and again, not have temporary workers who are working essentially full-time not be paid in a timely manner, but to provide some relief for the organizations that are struggling in this economic time, but continue to pay those employees on a regular basis, just every 2 weeks versus every week. And that was sort of the genesis.
Does it have, I'm sure it does, some concerns that after Oriella that there was a negotiation and a concern that people, for employers, that you would have to pay after every assignment, and this was meant to at least compromise and clarify that. And I know I've had long discussions with Mr. Cooper and about his clients and his desire to be paid their group to be paid twice a month as well. So I hesitate to get involved in something that took a long time for us to do some good and get here, not ignoring the fact that there may be more work to be done, but I assume you've had some of those discussions.
Yes, Mr. Chair, thank you. And the L'Oreal versus Smith decision, there did need to be clarification about that, and that's what SB 9040 was for. We think that there's such a far nexus between the L'Oreal decision and our industry that would be very difficult through litigation to show that we're under that requirement. So we really didn't have any issue with L'Oreal. It was just the fix to L'Oreal, SB 940, and now all of a sudden we're involved. And yes, we were talking to Mr. Cooper's folks as well, and that's a temporary nursing model, whereas ours is there are two different issues, two different models. I understand that there might be some consideration how they might fit together, but really kind of a true temp agency model as opposed to our model, which is we consider to be employers of the employees.
But you are for profit.
There are some that are for-profit, some that are non-profit. Non-profits are exempt.
Okay.
Yeah.
Just to clarify.
Yes.
Okay. Would you like to close, Mr. Portantino?
That's what I said before, that we thought there was a gray area that the issue needed to be highlighted. Again, I think it's a case that the relief sort of matches the model, and so therefore I would ask for an aye vote. I understand the chair's concerns, and certainly respect the chair's opinion and input on this issue.
No, I have, as we've talked, I do have empathy for your situation and Mr. Cooper's situation, but I also hesitate to jump in the middle of something that took a long time to negotiate out and probably is best further discussed amongst the parties. And in reality, it would be, as someone said anyways, even if this bill does pass out. So with that...
Mr. Chair, one other question comes to mind. Where were you as 940 was moving through the legislative
Unfortunately,
process?
not involved in the discussions.
But you didn't pay attention to it as it was in policy?
L'Oreal, because L'Oreal we didn't feel that there was an impact from the L'Oreal decision. This was a fix to L'Oreal, and through some internal transition, et cetera, not involved in the 940 discussion.
Yeah, that's unfortunate.
Okay. Is there a motion?
Seeing no motion.
Don't hear a motion. We are going... I'm sorry.
I've been in the position of not getting a motion out of a committee. I thought it was rather rude. Your choice. Would you prefer a courtesy motion?
I'll respect the chair's.
Okay, we'll leave it to the chair.
This is a very democratic committee when the chair feels like being democratic. If you would like a motion, it's fine with me.
No,
since we have a couple members who are not here, but...
No, I'll respect the chair's wishes to continue to work on this issue.
Okay, appreciate it.
Right.
It's a discussion that should continue.
Thank you.
Speaking of charming members, Mr. DeLeon is here. Mr. DeLeon, no. Mr. DeLeon, and then
Senator.
Skinner, and then I think that would bring us to Mr. Nilo's bill, and he's going to have staff present to him.
Mr. Chair, Mr. Desagné,
Future senator, perhaps.
Mr. Senator, how you doing?
I'm fine, thank you,
It's
Mr.
an honor and
Assembly
pleasure
member.
to be here. Senator Leno, in absentia, Mr. Weiland, the Vice Chair, who's not here right now, but thank you for the opportunity to present AB 2468. This bill seeks to encourage more employers to provide supportive work environments for new mothers by creating a volunteer program. Let me underscore and emphasize, and unfortunately the Republicans are not here, but I do want to underscore the word voluntary program that offers employers the opportunity to use a designation, which would be the breastfeeding mother-friendly workplace, if they implement, in fact, a comprehensive workplace breastfeeding policy. The significant health benefits for both breastfeeding mothers and their babies are very well documented. Breastfeeding mothers have reduced risk for breast as well as ovarian cancer and type 2 diabetes. Breastfed babies specifically are less likely to develop ear infections, develop a stronger immune system, combat stomach viruses, as well as asthma, diabetes, and childhood obesity. There are also potential benefits for the employers themselves, including reduced worker turnover rates, shorter maternity leaves, lower absenteeism due to a sick child, higher morale among employees, as well as lower and fewer health insurance claims. I believe this program will be a win-win-win for California mothers, their babies, as well as the employers. With me here to testify are Terry Cowger-Hill on behalf of WIC California, WIC Association. I don't believe Shannon is here, but representing the American Congress of Obstetricians. But we have the California Nurses Association with us as well today. I respectfully ask Mr. Chair as well as Senator Leno, I vote.
Witnesses in support.
Yes, Mr. Chair and members, Terry Cowger-Hill on behalf of the California WIC Association. Moms with children are one of the largest growing segments of the workforce and workplace, and we are strong supporters of breastfeeding as a health benefit to the children. Almost 50% of working moms that have newborns go back to work within that first year, often in the first couple of months. And so if we can promote and support businesses to comply with the law and kind of give them some recognition for providing the sanitary space and privacy for the moms to either express breast milk or feed their babies on break, that would be a good thing to do. We see this as very positive and non-punitive, and we've received bipartisan support all the way through, and appreciate Mr. De Leon's leadership on this issue. Thank you.
Mr. Chair, members, this is Deanna Firm on behalf of the California Nurses Association. We are also in strong support of this bill for all the reasons stated. We think that this is a great bill, and we applaud Mr. De Leon for his work on it. Thank you.
Other witnesses in support. Mary.
Mary Weiberg, Commission on the Status of Women. We concur. We also think that even though we've got a great law, it's very difficult for women to get the support they need from employers, and this is one way to encourage that. Thank you.
Thank you, Mary. Thank you for sticking with us all day. Any witnesses in opposition? Mr. De Leon, would you like to close? Do we have any questions of Mr. De Leon?
Just a motion.
Just a motion.
I heard that loud and clear right there. Senator, I just respectfully ask for an I vote.
Okay. We'll ask the Secretary to call the roll.
Senator Desagné.
Aye.
Desagné, aye. Weiland, Duchesne, Hollingsworth, Leno.
Aye.
Leno, aye. Yee.
We'll leave that on call. You have 2 votes. You need 2 more votes. Thank you, Mr. De Leon. It's always a pleasure. Ms. Skinner. I don't know. He was here for quite a while. Welcome.
Thank you, Mr. Chair, members. The bill I'm presenting today is a rather simple bill, AB 1213. It adds the Superintendent of Public Instruction as a member of the California Governor's Committee on Employment of People with Disabilities. There was a previous bill in 2002, called the Workforce Inclusion Act, AB 925, which gave the Governor's Committee more authority to collaborate with agencies and develop a strategy to include people with disabilities in the workforce. But when 925 was enacted, there was no involvement of individuals responsible for the actual administration of educational programs. So this limited representation from the Department of Education has hindered the committee's effectiveness when coordinating with ongoing educational programs for people with disabilities. So AB 1213 is a step to broaden the Governor's Committee and ensures that educational programs remain a priority when planning workforce development for youth and adults with disabilities, better policy development and interagency coordination, and a smoother transition of youth from school to workforce. My sponsor, the representative from the World Institute on Disability, unfortunately called me this morning and was ill, so not able to join us. But all of the organizations within the World Institute on Disability are basically supporting and sponsoring this bill. The bill has no opposition. It has received bipartisan support, and I respectfully ask for your aye vote.
Thank you. Witnesses in support? Any witnesses in opposition? Keeping in the strong tradition of your assembly district and Assembly Member Aaroner, any comments or questions?
I move the bill.
There's a motion. Would you like to add anything else?
Not unless there's questions.
Okay. There's a motion. We'll ask the Secretary to call a roll.
Senator DeSaulnier?
Aye.
DeSaulnier, aye. Wyland, DeCheney, Hollingsworth, Leno?
Aye.
Leno, aye. Yee.
Okay. 2 votes. We'll need 2 more votes, but we leave it on call and hope that Senator DeCheney and Senator Yee are heading this way, as we only have 1 bill left, and that's Mr. Neelo's bill. Thank you.
Thank you so much. Thank you.
Okay, we'll lift the calls in anticipation of Ms. Kern coming down to present Mr. Neelo's bill and also being joined by Senator DeCheney and Senator Yee. Sure. Why don't we just go in order, Rosa? Okay, first one. Yeah, you're right. So our first one is item number 1, AB 179. There wasn't a motion on that. Why don't we hold that to the end and see if there is a motion as a courtesy when we're joined by the other 2. So we'll go on to item number 2, which is AB 569. The current vote is nothing.
Senator DeSaulnier?
Aye.
DeSaulnier, aye. Wyland, DeCheney, Hollingsworth, Leno?
Aye.
Leno, aye. Yee.
Did you need a motion on that, or you already had it?
We did need a motion.
I move the bill.
Sorry, I'm getting groggy. Okay, we'll pause for a second here, just so you know where we are, Mr. Yee. We are raising the call. We want to go through the call list right now, and then we'll go to Mr. Neelo's eminently competent staff. We are on item number 2, AB 569 by Mr. Emberson. There was a motion by Mr. Leno, and myself and Mr. Leno have voted aye at this point.
Senator Yee?
Aye.
Yee, aye.
Next, item number 3 by Assemblymember Fong, AB 933. The vote currently is 3.
Senator
Shiny.
Do you want me to go back to 1 or not?
Yes.
To 1?
So, everyone has a lot of power in this committee today. We're lifted the calls. We still have 1 item to go, so the idea is to run through everything on call and then have a presentation on the last item. So we'll go back to item 1. Item 1 is AB 179, Mr. Portantino. We have only heard the testimony. We do not have a motion at this point. Is there a motion? The chair is voting no. We're not holding the bill. We as a courtesy, as we can hold the bill as a courtesy. The assembly member said that if there was a motion, we'd take a vote. If there's no motion, then the bill will die in committee, and we'll grant reconsideration. There's no motion. That was the point of the drill. So AB 179 fails for lack of a motion. But reconsideration will be granted. Item number 2, Mr. Emerson, the vote currently is 2-0.
Mr. Chairman, can I ask a question on this one? The part of this that, frankly, was and I guess I'm trying to be consistent on different things, but we believe in collective bargaining, being able to do these things. Why would we pick specific workers? And I'm sorry I wasn't here for the conversation to see if that part of it got answered. But I'm a little uncomfortable with the carving out of specific industries, although I'm not particularly uncomfortable with the notion that collective bargaining, you can design whatever meal and rest period you find appropriate to the conditions of your work environment. And I don't know what the discussion on that was. I'm sorry.
Actually, we didn't. I don't remember a discussion about that at this point. I've had discussion with the sponsors and the author about it in the past. My thinking was if you could, there's agreement. These are somewhat unique, although there are many unique jobs that in the transportation field, having worked in that as a warehouseman and as a helper many years ago, if they can bargain the flexibility, I thought that was a step in the right direction. I understand the arguments that we want a complete solution.
With you. I mean, it's sort of my same problem with the Berryhill bill. But I mean, did you vote yes? The chair voted yes. Who's an aye?
Yes. The vote right now is 3-0.
Oh, okay. Okay.
So we'll call the roll. That's okay?
1569?
Yes.
Senator Wyland, Senator DeCheney?
Aye.
DeCheney, aye. Senator Hollingsworth?
Okay, that bill is out 4-0. And we're going to assume that Mr. Hollingsworth is not joining us since we haven't heard otherwise. So that bill is out. We go to item number 3 by Mr. Fong. The vote right now is 3-0.
Senator Wyland, DeCheney?
Aye.
DeCheney, aye. Hollingsworth?
That bill is out 4-0. Item number 4, AB 1213 by Assembly Member Skinner. The current vote is 2-0 with obviously the chair voting aye.
Senator Wyland, DeCheney?
Aye.
DeCheney, aye. Hollingsworth? Yee? Aye. Yee, aye.
That bill is out 4-0. Let's see. Where are we now, Rosa?
1696.
1696, Mr. Berryhill. The current vote is 3-0.
Senator Wyland, DeCheney? Hollingsworth? Leno? Oh, I'm sorry, I had those two.
Okay.
So,
We'll
3.
leave it on call, or
Well, I have that same problem, only more so on this. If we're going to make it conform, we should make it conform. And I'm not interested in carving out only one small section of workers. It doesn't even include firefighters if it's public safety. I mean, it just doesn't make sense to me. And I don't know. The author sort of answered the question, said it should be a different bill, but you're either going to do it or you're going to do it. It's only cops.
it's just cops, but the firefighters spoke in support of it.
But it doesn't include them.
It's public officers.
Oh, it's okay. Okay, but it's still. I don't understand. If you're going to change it, we either believe that it is correct, as we do in child support and as Social Security Administration is doing, to allow these benefits up to age 19 if you're still in high school, or we don't. And I'm not quite sure why I believe about it for cops and I don't believe it for roofers.
Well, speaking for myself, I think it's because we had it in front of us. I think there was compelling testimony as to specific need, and I think others spoke to the world has changed. Actually, I think you brought the comment up about people going into the first grade sooner and then getting extended, and I sort of see that as that's one of the things.
Not only cops' children.
Understood. For me, I thought it's a good start, yeah.
I don't think it'll finish if you allow cops to have it. Because there'll be nobody left. There won't be anybody.
Okay, well, we'll leave that on call. If you have any second thoughts, we won't torture you any longer.
That's all.
All right, let's see, where are we? Item number 6, AB 1827, Arambula. The current vote is 2-0 with the chair voting aye.
Senator Wyland, DeCheney?
This is the workforce one?
Yes, this one stop.
DeCheney, aye. Hollingsworth? Yee? Yee, aye.
That bill is out 4-0. Brings us number 7, AB 2032, Mr. Davis, Employment Entertainment Work Permits. The current vote is, there is none, so we heard this. We need a motion.
Need a motion.
Yes, so moved.
Moved by Mr. Leno. We'll call the roll, please.
Senator DeSaulnier?
Aye.
DeSaulnier, aye. Wyland, DeCheney?
Aye.
DeCheney, aye. Hollingsworth? Leno?
Aye.
Leno, aye. Yee? Yee, aye.
That bill is out 4-0. Item number 8, AB 2055 by Mr. Delatorre. We will need a motion.
Senator Desaulniers.
Aye.
Desaulniers, aye. Wyland. Duchenne.
Delatorre, aye.
Duchenne, aye. Hollingsworth. Leno.
Aye.
Leno, aye. Yee. Yee, aye.
Bill is out 4-0. Item number 9, AB 2058 by Assemblymember Block. Do we need a motion? Moved by Senator Leno. We'll call a roll, please.
Senator Desaulniers.
Aye.
Desaulniers, aye. Wyland. Duchenne.
Aye.
Duchenne, aye. Hollingsworth. Leno.
Aye.
Leno, aye. Yee. Yee, aye.
Okay, that bill is out 4-0. Item number 10, AB 2187 by Assemblymember Arambula. The current vote is 2-0.
Mr. Chairman, I apologize. I did hear part of this one while I was out of the room, but I had concerns that I think were similar to Senator Leno about the criminality issue here, and especially the part that I heard a testimony that you would then ask somebody to pay for being a defendant in criminal action.
So he's agreed to take that out of appropriations.
Okay, he agreed to take all of the criminal piece. I mean, civil penalties are paying the tax.
It would still be a misdemeanor with the same fines and the same potential jail term, but there would be no costs covered by the defendant if convicted. So it would not set that precedent in criminal cases.
But there is currently no crime of
It's created a new misdemeanor, correct?
We did have quite a bit of discussion with just Senator Leno and
And if you
myself.
want, they've got a chart of criminal
Is that what this was?
status for other labor code violations. But he did agree to take out the precedent-setting court costs in a criminal case.
And did they solve the what does willful mean?
No. But he did commit to continue to work with the opponents. I don't know if that's good enough, but we were going to work on it together.
Okay, you're
So
gonna
I think
commit to work on
we
it?
all share the concerns that this might be, we all want to get after people who are willfully not paying wages, but we have concerns about how they've gone about it. So
You referred to public safety as a new crime?
it goes to probes.
On a conditional basis without commitments to the floor, because I think it's a big problem.
I think we all share your sentiments, that we want to do the right thing, but we're not sure that this isn't going to cause some unintended consequences. So that, yes, did you call it?
No, not yet.
I'll ask the Secretary to call a roll.
Senator Wyland. Duchenne.
Arambula.
Aye.
Duchenne, aye. Hollingsworth. Yee. Yee. Yee, aye.
I have a character flaw I want to facilitate. I've lost my train of thought. 11, AB 2188 by Assemblymember Bradford. It's a good bill, but in keeping with Senator Duchene's comments, I've decided to vote no. No, I'm kidding. Just to kill a bill. I need a motion to move it to appropriation.
And that is amended? Or no?
As amended?
As amended.
No amendments.
No amendments?
The motion is to move to appropriations.
Yes.
Okay. Senator Desaulniers.
Aye.
Desaulniers, aye. Wyland. Duchenne. Duchenne, aye. Hollingsworth. Leno.
Aye.
Leno, aye. Yee. Yee, aye.
Item number 12 is by Mr. Cotto, AB 2253.
Need a motion.
We need a motion by Senator Leno. We'll ask Secretary to call a roll.
Senator Desaulniers.
Aye.
Desaulniers, aye. Wyland. Duchenne. Duchenne, aye. Hollingsworth. Leno. Leno, aye. Yee. Yee, aye. 4.
That'll bring us to item number 13. Do we have agreement? Go ahead, turn your mic on.
With the permission of the Chair, Gideon Baum, Senate Labor Committee, the amendments that were suggested by the Chair having to do with the sunset and the reporting requirements have been dealt with. However, we're still waiting on final notice from Knight's office on the amendments suggested by Senator Leno, though it sounds like there's something agreed to in concept.
Well, we'll need to have those shortly.
Assemblyman Knight came over to my ear and said that he agreed that on the first offense, the C license would be revoked. On a second offense, the state contracting license would be revoked. And with that, I'll support the bill.
So that's a motion to approve
As proposed to be amended.
as proposed
Correct.
to be amended.
What do they mean as proposed to be amended in appropriations?
Yes, so we're moving into appropriations with the understanding that the authors agreed to take the amendments discussed today.
Amen.
But, well, we're going to do it here. We'll do the amendments here, right?
Sure, that'd be preferable if it's,
Yeah.
Oh, so as amended?
yes.
So as proposed to be amended before.
No, it's, the motion is
As amended.
as amended.
To appropriations.
Right.
Senator DeSaulnier?
Aye.
DeSaulnier, aye. Wyland? Duchenne?
Aye.
Duchenne, aye. Hollingsworth? Leno? Leno, aye. Yee? Yee, aye.
Item number 12, AB 2340 by Mr. Monning, and the previous one is 4-0, so that vote is out. That bill is out, by Assemblymember Knight. So now we're on to Mr. Monning's bill, 2340. The current vote is 4-0.
4-0.
So that bill is out 4-0. AB 15, AB 2349 by Mr. Fong, Youth at Work. The current vote is 3-0.
Senator Wyland? Senator Duchenne? Duchenne, aye. 4-0.
Okay, that bill is out 4-0. Item number 16, AB 2364 by Mr. Nava. The vote currently is 2-0. Go ahead and call the roll.
Senator Wyland? Duchenne? Duchenne, aye. Hollingsworth? Yee?
This is not.
Yee? Yee, aye. 4.
That's 4-0. That bill is out. Item number 17, AB 2397 by Solorio. The current, we will need a motion on this bill. Moved by Senator Leno. This is, the motion is to pass to appropriations.
No.
I'm sorry.
Just pass.
Just pass.
Senator DeSaulnier?
Aye.
DeSaulnier, aye. Wyland? Duchenne?
Aye.
Duchenne, aye. Hollingsworth? Leno?
Aye.
Leno, aye. Yee? Yee, aye. 4.
Bill's out 4-0. Item number 18, AB 2468 by Mr. DeLeon. The vote currently is 2-0.
Senator Wyland? Duchenne? Duchenne, aye. Hollingsworth? Yee? Yee, aye. 4.
Item number 19, AB 2523. The current vote is 3-0. This is Assemblymember Ng.
Senator Wyland? Senator Duchenne?
Aye.
Duchenne, aye. 4-0.
Okay. Let's skip over Mr. Nilos and come back to that, and that'll finish us. Item number 21, AB 2570, Ma. That's 4-0. That bill is out. Item number 22, AB 2696 by Assemblymember Bass. We need a motion. Moved. I'll ask the Secretary to call the roll.
As amended.
As amended.
Senator DeSaulnier?
Aye.
DeSaulnier, aye. Wyland? Duchenne? Duchenne, aye. Hollingsworth? Leno? Leno, aye. Yee? Yee, aye.
Bill is out 4-0. Item number 23, AB 2726 by Ms. Lowenthal. We need a motion. Moved. Ask the Secretary to call roll, please.
Senator DeSaulnier?
Aye.
DeSaulnier, aye. Wyland? Duchenne? Duchenne, aye. Hollingsworth? Leno? Leno, aye. Yee? Yee, aye. 4.
4-0. That bill is out. And the last bill is item number 25, AB 233774. Is that right? 2774 is done. That bill is out.
2774.
Yes.
I need to call that one.
Okay.
Need a motion. Oh, no.
We need it. We'll both catch our breath. Last item, 2774. Is that out?
No.
Okay. So we need to call a roll. The current vote is 2-0.
Senator Wyland? Senator Duchenne? Duchenne, aye. Hollingsworth? Yee? Yee, aye.
Okay.
4.
We'll ask Ms. Curran to come and present Mr. Nilo's bill quickly so we can get Public Employees Committee in here. Right. Go ahead.
Okay, I'm presenting AB 2538 for Assemblyman Nilo. The bill sponsored by EDD. It's a simple cleanup measure to the UI code, and it will ensure the proper operation of the unemployment insurance program. Specifically, the bill lets EDD service a notice of levy on a person or employment unit to collect delinquent contributions, penalties, and interest, either electronically or by first-class mail. It provides EDD with the authority to prosecute criminal violations in the county where the defendant or defendants were doing business when the alleged offenses occurred. It deletes outdated references making a person ineligible to receive state disability insurance payments if he or she is receiving a workers' compensation maintenance allowance for vocational rehab, a benefit that no longer exists. And lastly, it deletes the statutory requirement that disability insurance benefits must be paid by check. This last element we're going to be removing because it's in Assemblyman Bradford's AB 2188. And that's all. Ask for your vote.
Anyone feel a compelling reason to speak? Seeing no one, there's a motion as amended. We'll ask Secretary to call the roll.
As amended.
As amended.
Senator Desaulniers.
Aye.
Desaulniers, aye. Wyland. Duchenne. Duchenne, aye. Hollingsworth. Leno.
Aye.
Leno, aye. Yee. Yee, aye. 4.
Okay. 4-0. That bill is out. Nice job.
Okay, thanks.
All right. That concludes our business today. Thank you all for attending. We're adjourned. Thank you all.
Thank you, sir.